Hello and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. I thought I would give, in this particular episode, a little more detail about the procedures that are involved in deportation/removal proceedings and more or less what to expect, when you can expect them, and essentially what's needed to help fight your case. So first of all, the deportation proceedings are started by what is called a notice to appear, or an NTA. That is the document basically where the immigration will serve the court to begin proceedings. Now just to keep in mind here that the NTA can be done, but unless it is actually served on the court, you're not in deportation proceedings. Now, before you get to the point where you understand that you're in deportation proceedings, I need to inform you what ICE normally does. A lot of times you will have a criminal history, you'll just served a sentence, you'll get pulled over by the police for speeding, for a ticket, whatever it is, and then the next thing you know, you end up in immigration detention. Even if you're not in immigration detention, you'll be in criminal detention, and an ICE official will visit you. They will come up to you and essentially say you have no hope, you'll have 20 years of staying in detention, you're not going to be able to fight your case no matter what anyone says. Just sign the piece of paper and everything will be fine. And then of course you sign the piece of paper, which is your voluntary deportation, and the next thing you know, you're on a plane or a bus outside the country. So, I don't want to say every ICE official does that, obviously, but I have, over the last 20-some years, heard so many of the similar stories that it seems to me that does seem to be a mode of operandi for many ICE officials. So the first and number one piece of advice that you should have is do not sign anything from an ICE official when you are in detention. Given that, the only thing you should sign, if you understand it, what it is you're signing, is that you want to fight your case and go see the immigration judge. But if there's any ambiguity at all, if there's any question in your mind about what you're signing it, you do not have to be forced to sign. No matter how intimidating the official may be to you, no matter what they say to you, under the law, you are not required to sign. So what you do is you say thanks, but no thanks. I've heard from an immigration attorney that I don't have to sign that. I would like to fight my case in the immigration court. Thank you. And then, of course, get somebody, or you can call the immigration attorney. And by the way, I have lots of local numbers at many of the immigration detention facilities, so that, if you use the telephone there, that doesn't let you dial anywhere else but locally, you can dial my local number and it will get to me, to my office, so I'll be able to give you a consultation and let you know what can be done. But in any event, assuming that you haven't signed the voluntary deportation, which, by the way, even if you do, there's ways that I can fight the case to get it revoked, but why go through that trouble if you don't have to? So now let's assume that one way or another, let's say you're in detention and you get your first hearing in front of the immigration judge. And just to keep in mind, not all immigration proceedings are in detention. As a matter of fact, many of them are not in detention. Many of them, you'll be receiving the notification in your mail, and it basically says you need to be here at this time, at this place, and you need to make certain that you are there, or else you will have an order of removal in absentia. So you don't want to do that. You want to make sure you go to your court hearing. Well, given that, when you're in the first hearing, if you're in detention, then what you're going to want to do is go to what's called a bond redetermination hearing. So the bond redetermination hearing means that if you're in detention and you're in front of the judge, that you have the opportunity to fight the fact that you either were denied a bond from immigration or that you want a bond that a reasonable person can pay. In which case, normally, if it's done right, and let's say immigration told you you had to pay $50,000, you'll probably get the judge to agree to $5,000, okay? So I know it's no pleasure being in detention, but for an extra 5 to 10 days and going in front of the judge, you might be able to greatly reduce the amount of that bond. So after that, if you're in detention, then you do the bond. Then what will happen is you can then proceed forward with the actual merits of the case. So the merits of the case is when you look at the notice to appear, you will see several allegations on there. And I would absolutely strongly suggest that you do not go and try to represent yourself in immigration court because you are not the friend of the immigration judge, you are not the friend of the trial attorney. You're just another number to them, and they have 10,000 cases in front of you and they have 10,000 cases behind you. So you definitely need someone who is on your side, able to represent you, and essentially an expert at deportation proceedings. So when you have the allegations, it'll say something like, you are not a citizen of the United States, you are a citizen of Mexico, El Salvador, the Philippines, whatever. You entered the United States on such and such a day, on such and such a visa, and it expired, and then it'll have a section of, if you committed crimes, you committed a particular crime on this date, this time, and this is what it is, and then it will have a section on there of why you are removable. It'll say you are removable under this section of law because you overstayed, or you committed a crime of moral turpitude, or whatever, you're an aggravated felon, and so forth. And so the attorney during the master hearing will go through each of those allegations and admit or deny them, and then admit or deny the grounds of removability. Just so you know, I never ever admit to a criminal ground of removability. It is their burden to prove it. They do have to prove it, and what will happen is at the appropriate time, when they prove it or don't prove it, then you can go forward with whatever grounds of relief you have. So that's the master calendar, okay? So the master calendar, while it doesn't take long, is very important to the entire scheme of the case, because if it's pled wrong by the attorney, if forms of relief are not asked for, if there are things that are admitted that should not have been admitted, it's very difficult to turn it around. So you want to make sure that it's done properly. There are even times when you don't want to admit you're not a U.S. citizen, because sometimes you might qualify for derivative citizenship. Sometimes you don't want to admit the day that they say you came into the country, because maybe you're a month away from qualifying for cancellation of removal. Maybe you don't want to admit, obviously you don't want to admit the crime, because if they can't prove that you committed that crime, then you're not inadmissible based upon the crime. So there's different things that you could fight. Now, after you deny whatever it is that's denied, after the master calendar hearing, it will go to a contested hearing. And the contested hearing is meant to go over each one of those allegations that you denied or your attorney denied, and essentially fight the case, fight those allegations. Then what will happen is the judge will determine whether to overrule your objections or whether to sustain them. And then the judge may or may not find you removable based upon the allegations, and may find you removable based upon all the charges in the NTA or one of the charges, whichever one. And then afterwards, your attorney will then go forward and tell what forms of relief you might be eligible for. Now, in immigration court, there's a lot of different forms of relief depending on what it is that you might qualify for. Let me just list a few. You can apply for asylum, withholding of removal, convention against torture. All of those are related to what will happen if you go back to your home country and are persecuted, tortured, imprisoned, or if you have been in the past, or if the country conditions have changed to allow that. Next, you could possibly qualify for cancellation of removal for lawful permanent residents, or cancellation of removal for non-permanent residents. That all depends how many years you've been here, what crimes you may or may not have committed, what relatives you have in the U.S., all kinds of other things. Then you might qualify for adjustment of status, depending what family members you have in the United States and whether they filed a family petition for you, and if the visa number is current. You might qualify to adjust through them based upon the visa preference system. You might qualify to adjust based upon an immediate relative's petition, depending if you're married and so forth. You might qualify for registry, depending how long you have been in the U.S. You might qualify for other kinds of waivers, depending, for example, if you didn't qualify for the green card in the first place based upon some kind of misrepresentation on your whether you were married or single. There's all different kinds of ways. You might qualify to have the case terminated and then do an adjustment after. You might qualify to have the hearings continued or administratively closed while waiting for a visa number to become current, or while waiting for various items to happen to make you eligible for certain things in the future. With the new DACA or deferred action, you might qualify for that. Prosecutorial discretion, depending on your situation. Humanitarian paroles. There's all kinds of stuff as to what you might be able to apply for, even if it's outside the immigration court. You might qualify for the U visa, for VAWA cancellation, okay? So as you can see, there are a lot of different forms of relief that you can apply for. So you will let the judge know which forms of relief you want to apply. The next hearing date will be for filing. So then, the attorney will get everything prepared, all the filing applications, and what will happen is at the next hearing, a very short hearing, but still at the next hearing, you will actually file your items. Some items don't get filed with the court. Some get filed with USCIS. Some get filed with the Service Center in Texas. It just depends what it is you're filing. And then after that, there'll be another hearing to follow up and get other information, whatever's needed. And the last hearing will be a trial, at which point they might go on maybe more than one hearing. It just depends. But you'll have trial on the various matters. And then the next hearing, usually, will be the decision of the judge that will orally read the decision normally in court as to whether it's approved or denied, and which applications are approved, which are denied, and then you will decide at that point whether you want to appeal or not if it's been denied, or whether you want to just give voluntary departure. It all depends. So there's I've given an extremely condensed summation of immigration court from beginning to end, so that will at least give you an idea that number one, you need to make sure you have a qualified attorney represent you, but number two, don't just go in there and plead to everything they give and admit everything. That's the worst thing you could do. There's many times a lot of help that you could get in order to fight your case, in order to try to remain here. So give me a call, make a consultation. I'll be happy to help you. More on the coming video.